Trooper Proctor faced a lot of scrutiny about conflict of interest, about how he handled the evidence, about lewd messages and the horrible words that he used to describe the defendant in this case. Let's bring in my guest to discuss. Joining us now, national trial attorney Michael Jaafar. Michael, good to have you on. This is my first time speaking to you about the deadlocked jury and the Allen charge that the judge read to them earlier in the day. Your thoughts on where we are in deliberations?
I'm not surprised. Clearly, the jury did not believe or buy the conspiracy hoax. I'm glad they didn't. I agree with them. Clearly, there's some jurors in there that are not agreeing with the other jurors, but they did not believe it. You know, Julia, let me give you my theory of the case just briefly. I think Karen Reed is the arch villain in the John O'Keefe story. Okay, here's the way that we got to this point. The whole conspiracy cover-up thing, that does not come from an attorney, right? An attorney has to be sold on this by their client, not just convinced, not just suggested. You don't walk into a lawyer's office and say, I killed somebody, help me cover it up. And he says, we're gonna go with conspiracy on this one. An attorney knows that they can only bring up conspiracy and cover-up one time in their career, and they better be right, otherwise their credibility is destroyed. So Karen Reed had to sell her attorneys on this theory. Why did she do it? Let's look at the facts and the evidence. It's undisputed, and I think the jurors are in that box are talking about it. When she showed up at the scene of the crime at the time of the crime, what do we know about that incident? She was blitz drunk, not only at that time, but the day after. Right? She was severely drunk. So had she, let's say she hit John O'Keefe unintentionally by accident, a man that she claims she was merely dating, she did not love, they were not in love, right? What would have happened if she would have called the police? They would have the ambulance. They would have showed up. She was so severely drunk, and she knew that at the time, that if he died, she wouldn't have been charged with a misdemeanor. She would have been charged with felony murder. She would have went to jail for a very long time. She could not take that in, so she drove home, hoped for the best. When he didn't show up, she started concocting her cover-up and her scheme, and that's where, in my opinion, she came up with the whole conspiracy cover-up thing. And only a narcissist would throw shade and put a whole entire community into chaos over them covering up for themselves, right? So in my opinion, the evidence shows that Karen Reed was there. She, intentionally or not, hit John O'Keefe, and he died, and she began the whole conspiracy thing. And when the defense took the case, they only took it for 2 days. They did not bring up a single witness that verified the conspiracy and the cover-up, or did they point a finger at any other legitimate person that could have actually killed John O'Keefe? What are we supposed to believe? That the Alberts killed John O'Keefe and then covered it up and put his phone in his pocket and started calling it a bunch of times, pretending that they were looking for him, and that they took charge of the broken taillight and put it next to his body? I mean, this whole thing is ludicrous. I think that's why you see this jury note that we are hopelessly deadlocked. Right?
Sounds like someone in that jury room believes one side or the other. I think what you're saying is valid in terms of the strong evidence about what she said, and someone not being able to let go that she was the first one to introduce herself as the potential defendant. No one went looking for her. No one banged on her door. She was there at the scene saying things that suggested that she was there. But then you've got these injuries and the way they don't look like a collision. And I think that's something that someone could probably very much hang on to and say, there's no way I can convict someone when I'm looking at this. This doesn't have anything to do with Trooper Proctor. This is just the evidence. Michael Jaafar, I want to... Go ahead. React to that. Yeah, react to just that evidence. That's not the conspiracy, but these are the hard facts.
Yeah, let me react to that. So even the defense expert who was testifying, who said, the person that was appointed by the feds, said, you know, these injuries are not relatable to an injury. Even on cross-examination, he admitted, well, yeah, if you fall back and hit your head on the curb, that could create 1,000 pounds of force and that could kill you. I had a client in April fall back, hit his head on stairs and died instantly, a young, healthy guy. So it happens. So even the defense expert testified on cross-examination that this could happen, and those injuries on the arms were tested. There was no canine DNA. I think all of this comes back to the January 4th hearing, where the defense filed a motion to turn over evidence, which I think was the gravest mistake by the prosecution, to not willingly give this evidence to the defense, which allowed the defense air. They allowed this whole conspiracy hoax to have a lot of air because of the mistake and the hubris of the Massachusetts State Police and the prosecution. They made a grave mistake and they gave her what she wanted. But those injuries, in my opinion, also tie to the death that John O'Keefe suffered. I believe that the evidence and the DNA evidence and the experts, all, including the defense DNA, the defense expert, give you the ability to see how she would have killed him with that car.
So many angles to look at for this jury. They've been at it for 5 days. They were read that Allen charge by the judge, something that's rooted in the law for her to stick to when she's telling them, go try again. You have the best information. You're in the best position to decide this case. So we've been looking through the Court TV archives for the times that the Allen charge has been read and what's been the outcome. Here are a few that some of our viewers may remember. Now, Ty Tyrone Tucker, the Treehouse Murder Trial that happened in Key West, Florida, he represented himself. And he had some strong evidence on his side. And there was a point where this jury, he was accused of killing a man, injuring a woman who said that he was not her attacker. The jury came back deadlocked. The judge read them the Allen charge. They went back and they came back still deadlocked. His retrial has not happened yet, but the prosecution has said that they are going to retry him. In another case, Catherine McBanawa, also in Florida, but in 2019, she went to trial with her boyfriend, Sigfredo Garcia, accused of being part of a murder plot to kill law professor at FSU, Dan Markell. Her hitman boyfriend, he was found guilty in that joint trial, but the same jury wrote back that they were deadlocked about her guilt or innocence, read the Allen charge, and she was then released because of a mistrial. But years later, she was retried and found guilty, sentenced to life in prison without parole. The last one, though, Dr. William Husel. He was accused of multiple counts. His jury was deadlocked at one point. They were read the Allen charge. They couldn't decide between whether he was being merciful to his patients with the amount of drugs that he was giving them or if he was euthanizing them. But after that Allen charge, they came back with a not guilty on all of those counts against him. It was multiple patients that he was accused of killing. Michael Jaafar, it's possible this jury could come back with something other than we're still deadlocked.
I'm hoping they come back with guilty on the second and third charge. I don't
think
believe
you put it on mute.
No, I can. Can you hear me?
All right, go ahead, Michael.
Sorry. I hope they come back with a guilty on the second and third charge. I don't believe that the top charge has been proven beyond a reasonable doubt, the murder to believe it or not. But I don't think they will. That instruction was a cry for help. The note to the judge was actually a cry for help. The impolite version of the reading of that is there's a couple of people in this room that won't listen to reason. No matter what we tell them, no matter how much we reason with them, they're not going to do it. Please do whatever you can to convince them to listen to reason. That's how I read that. That's the impolite reading of that note. So because of that, when you have somebody that's that much of an obstinate type of factor in a jury room, I don't see them changing, right? This isn't the 12 Men movie, you know, where one person convinced the other 11. I hope they come back with guilty for the second and third charge. I think it has been proven beyond a any shadow of a doubt, not the murder too. But I don't think they will, Julia. I think we're looking at a hung jury. It really stinks that we're looking at that. I think we're looking at a hung jury before 4th of July.
Yeah, that's definitely what happens more often than not. Michael Jaafar, stand by. The jury selection slated to start next week. Still with us, National Trial Attorney Michael Jaafar. Michael, this is the same charge that Hannah Gutierrez was facing. It's going to be the same evidence, essentially, against Alec Baldwin. Why do you think a jury may come back with a different verdict, if you do?
I think they'll come back with the same verdict. I mean, obviously, it won't be the same jury. But if they don't come back with the same verdict, I think it'd be a mistake. It would be it would be incongruent with what they did with Hannah Gutierrez. And here's why I think that. I think that she should have been found guilty, and she did, of the charge. She wasn't charged with first-degree premeditated murder. She was charged with a misdemeanor, right? So I think that his culpability was even a step higher than hers. That's why I think they should come back with the same verdict. He was not just an actor on that movie set who was handed a gun. He was the guy in charge. He was the boss of everybody there. He made hiring and firing decisions. He was bankrolling the movie set. I mean, he was in charge. When you are in charge, if I show up to an office and I give my employees a gun and I say this is okay, or if I hire a person to give them guns and they hand me a gun and I grab a gun and I shoot somebody and there's a live round, nobody would dispute that I'm guilty of something, right? Because I'm in charge. I'm the boss. I'm the one who brought everybody together, and my coordination was negligent, right? So it should be no different here, right? The only thing going for him is he's not an attorney, because we know that we don't hold a shot at anything. But you know, he should be found guilty of this, because he's being charged with a very benign, low level. A person died in his care. And he was negligent. And I think the evidence his whole defense of, well, I did not fire the thing, anytime somebody uses an exotic defense and says, this thing that works all the time just didn't work the time I used it, you're swimming upstream, Julia.
Well, I want to see if your analysis changes what you said about him being the boss, him being in charge. His defense wants to keep that out of this trial. We have this excerpt from a defense motion where they want to preclude his role as the producer. So they want him to come in there as an actor. Here's part of it and how it reads. It says, if the state is permitted to make improper arguments related to Baldwin's role as a producer, this is going to end up wasting the court's time with a mini trial litigating which producer had which duties, and there's no such thing as supervisory liability in criminal law. In the first place, he wasn't the only producer on this movie, Michael Jaafar. If they're able to be successful and get any words like boss, in charge, and producer out, do you think we've got a different case here?
Of course, but they have no shot at doing that, because that is the crux of the case. Because that actually is that's a relevant thing. It's like saying you're charged with, you know, being neglectful for one of your children dying, but you want to leave out the evidence that you're the parent and you're just a person in the same room as them. You know, I mean, it has no chance, and it has no chance of succeeding. They're going to let that in. They've already filed 3 motions to dismiss, by the way, and were denied. So it's going to be let in. It's so relevant. It's not like a prior criminal conviction, which is not relevant to what you're charged with. This is the crux. This is germane to the fact pattern, right? The fact pattern does not fit without it. You know, you can't. It's like saying that you drove the car but you didn't turn it on. It's a one continuous crime, right? His role is part of the crime. They won't be able to keep that out.
Position is certainly huge here. He's going to be saying the armorer position is more important, and we'll see what the state is allowed to argue in terms of his position. Michael Jaafar, stand by. Let's bring back in National Trial Attorney Michael Jaafar with us. Michael, we're seeing a lot of faces of Sarah Boone. What do you think the jury is going to see when she is at trial representing herself?
The heinousness of that. Well, first of all, this is not a person who's making rational decisions. The sad part of it all is that she has some severe mental health issues. These are mental health issues that led to this death of this person, and they're going to lead to her conviction. The heinousness of this is grotesque. That video is just disgusting. I've been seeing this case for a while now, and every time I see that video, because I'm claustrophobic, right? And a lot of people, probably members on the jury, are probably also claustrophobic. I can't even be in an elevator, right? So I can imagine some members of the jury also being in that situation where, like, he's in his suitcase, he's telling you he can't breathe. I mean, it's uncomfortable for me to see this, and she's going to be convicted. She's going to go to jail for the rest of her life. If she did not have mental health issues and did not have a video here, this case would have pled out and she would have had an attorney. But I'm glad there's a video to bring light to what really happened, because this man suffered. I mean, he suffered in the worst way. I wish I could go back in time and grab him by the lapels and say, don't get in that briefcase, dude. Like, what are you doing? I just don't know. Some of these people do these things, and he allowed himself to be zipped up in this suitcase. So I think when she defends herself, it's going to be her talking to the jury about how people have been impolite to her. She fired, what, 8 lawyers, and she said they just were not being nice to her. I mean, that's what we're going to see. It's going to be a spectacle. The trial is going to be very difficult on that judge because she's not going to be able to keep control of her courtroom. I mean, this
yeah, we don't know what kind of a defendant she will be, whether she'll be one who has outbursts, who's going to try and fight with the judge, or she's someone who's going to really try. She's been writing a lot of letters to the judge. It sounds like she's very involved in her own defense and has been critical of her own attorney after attorney. Let's bring back in attorney Michael Jaafar. Michael, we've got a situation here where Lori Vallow Daybell, the client, wants her speedy trial. She wants to go forward in August, according to her attorney. Her attorney says, I need way more time to go through all of this evidence and wants it to be in February. Who does the court side with?
They're going to side with the defendant because it's the defendant's call. When you're an attorney, you take on a representation of somebody exactly like Lori Vallow, right? Where she's already been convicted. She's already arch villain #1. She's public enemy #1. When you do that, with a specific mindset, right? It's not like the thousands of criminal cases you take on where a person wants to, get a favorable outcome. This is a person who obviously has a different goal in mind, right? She thinks that she's going to be going into the 3 layers of heaven with the prophet. Like, you take that on day 1. So you can't be shocked if she doesn't want you to be prepped for the case. You have no idea whether or not she probably just wants to get back to her Idaho prison. So they're going to side with the defendant. It doesn't really matter what happens here, but I mean, the court is going to want to get this off their docket as quickly as possible.
Yeah, maybe she wants to be back in the same zip code as her husband, her beloved Chad Daybell. Michael, I do want to ask you, though, there's another motion that's going to be on the table. She doesn't want, her team doesn't want the media coverage in this. They have some objections. They want the media to follow certain rules. There were not cameras for the majority of her trial in Idaho, but it may be a possibility here in Arizona. But I expected this case to plead out. Do you think, right before we get to break, do you think that that's a possibility here in this case?
I hope so, but I don't think it will because they're not going to. The prosecution is not going to offer anything of anything. It's just plead on the charges and don't even fight them. That would be malpractice for the attorneys. I don't think it'll plea out, but it could. I could be surprised.
That preliminary hearing is going to happen tomorrow. You can watch it right here on Court TV.